Today we will have some basic knowledge about what is CPC, that is Civil Procedure Code, and why was it enacted. So without wasting any time, let's begin with the question and answers round, and let's start gaining some basic knowledge about the Civil Procedure Code. The first question is, the Code of Civil Procedure came into force with the effect from which of the following dates? The options are A. 1st January 1908, B. 1st September 1908, C. 1st January 1909, or D. 1st September 1909. The correct answer to this question is option C, that is, the CPC came into force with the effect from 1st January 1909. The next question is, the code extends to which of the following? Options are A. Whole of India, B. Whole of India except the state Jammu and Kashmir, C. The whole of India except the state of Nagaland and the tribal areas, or D. Both B and C. The correct answer to this question is option D. That is, the code extends to the whole of India except the state of Jammu and Kashmir and except the state of Nagaland and the tribal areas. Then moving on to the next question. Among the following, in which section the term decree is defined? The options are A. Section 2 clause 1, B. Section 2 clause 2, C. Section 2 clause A, or D. Section 2 clause B. The correct answer to this question is option B. That means to say, the term decree is defined in CPC under the section 2 clause 2. So now let's see what is the definition of decree and what does decree means. So let's now talk about decree and let's see what does a decree means. Decree basically means the formal expression of an adjudication which conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit. One of the special characteristics of decree is that it can be either preliminary or final. Another characteristic of decree is that every judgment is a decree, but every decree is not a judgment. Decree can be passed on a day-to-day basis or a hearing-to-hearing basis also. So now let's move on to the next question, which is, decree includes which of the following? The options are A. The rejection of a plaint, B. Any adjudication from which an appeal lies as an appeal from an order, C. Any order of dismissal for default, or D. None of the above. The correct answer to this question is option A, that is, decree includes the rejection of a plaint. So now let's move on to the next question, which is, what does a decree include? The options are A. Any order of dismissal for default, B. The rejection of plaint, C. The determination of any question within section 144, or D. Both B and C of the above. The correct answer to this question is option D, that is, both B and C. This means to say decree includes the rejection of a plaint as well as the determination of any question within section 144. So let's now go on to the next question, which is, the order of dismissal of for default is which kind of decree? The options are A. Preliminary decree, B. Final decree, C. partially preliminary and partially final decree, or D, none of the above? The correct answer to this question is option D. That means to say the order of dismissal for default is no is not a decree at all. So now let's move on to the next question, which is legal representative means and includes which of the following persons? The options are A, the person who in law represents the estate of a deceased person. B, any person who intermeddles with the estate of the deceased. C, the person on whom the estate devolves on the death of the party. Or D, all of the above. The correct answer to this question is option D, that is, all of the above is correct, which means that the legal representative means a person who in law represent the estate of a deceased person, any person who intermeddles with the estate of the deceased, and the person on whom the estate devolves on the death of the party. So, moving on to the next question, which is order means the formal expression of any decision of a civil court which is not a decree. This statement or this definition is given under which of the following sections? The options are A, Section 2, Clause 2, B, Section 2, Clause 12, C, Section 2, Clause 14, or D, Section 2, Clause 16. The correct answer to this question is option C, that is under 2, Clause 14. The definition of order is given, which means that a formal expression of any decision of a civil court which is not a decree. Let's move on to the next question, which is the term public officer means what? The options are A, every officer in the service remunerated by fees or commission for the performance of the public duty. B, every person who holds any office by the virtue of which he is empowered to keep or keep any person in confinement. C, both A and B, and D, neither A nor B. The correct answer to this question is option C, that is, public officer means both A and B. That means to say that every officer in service remunerated by fees or commission for the performance of any public duty, and every person who holds any office by the virtue of which he is empowered to place or keep any person in confinement is known as a public officer. So now, after gaining information about that, let's move on to the next question, which is the foreign judgment means the judgment of a foreign court. The term foreign judgment is defined under which of the following section? The options are A, Section 2, B, Section 3, C, Section 6, and D, Section 13. The correct answer to this question is option A. That means to say the term foreign judgment is defined under Section 2 of the CPC. So now let's see what does foreign judgment as per the CPC means. Let's now see and learn what does a foreign judgment means. A foreign judgment is defined under the Section 2 Clause 6 of the Civil Procedure Code as a judgment of a foreign court. A foreign court under Section 2 Clause 5 of the CPC means a court situated outside the India and not established or continued by the authority of the central government. With the addition to that, let's also see what does a foreign decree means. A foreign decree is explained in the explanation 2 to Section 44A of the CPC as a decree with reference to a superior court means any decree or a judgment of such order or such court under which a sum of money is payable, not being a sum payable in respect to taxes or other charges of the like nature or in respect of the fine or other penalty. Shall in no case include an arbitral award, even if such an award is enforceable as a decree or the judgment. So now let's move on to the next question, which states that every dash is appealable. Fill in the blanks. The options are A. Decree, B. Order, C. Both A and B, or D. Either A or B. The correct answer to this question is option E. That is, every decree is appealable in the higher court. So now let's move on to the next question, which is the cause of action may be described as which of the following? The options are A. A bundle of essential facts necessary for a plaintiff to prove. B. An important subject of litigation. C. A point in question. Or D. All of the above. The correct answer to this question is option E. That is, a cause of action may be described as a bundle of essential facts necessary for plaintiff to prove. So now let's move to the last question of the day, which is no suit would like to set aside a decree on the objection as to which of the following. The options are A. Subject matter jurisdiction of a court. B. Territorial jurisdiction of the court. C. Pecuniary jurisdiction of a court. And D. Both B and C above. The correct answer to this question is option D. That is both the option, that is B and C, which is the territorial jurisdiction of a court and a pecuniary jurisdiction of a court, are correct to are correct. This was the end of our first presentation. Hope you all liked it and hope this presentation or video was able to teach you something about the civil procedure code. Thank you for watching it. Thank you.